Quarles is proud to be Quarles is proud to be a sponsor of several ACC chapters across the country, and that includes being a longtime supporter of the San Diego chapter. I've probably seen some of you at the ACC events at Ballast Point in particular over the years. We truly enjoy our and value our relationship with the ACC community and are grateful for the opportunity to connect with all of you and provide you some insights about the problems you deal with every day. With that, I'm very pleased to introduce today's speakers, my partners Heather Bukta and Megan O'Connor. They're the leaders of our data asset management, privacy, and cybersecurity team. And with that, I'll turn it over to Heather and Megan.
Great. Thanks, Evan. Lovely to have you all today and to be able to spend some time with you. Typically, when I give this presentation, it's in person and I'm walking, so it's going to be hard for me to. If you see me looking antsy, it's because I'm used to walking around while talking about these topics. So, as you know, to get us started, obviously the opinions and the thoughts that you're going to hear from Megan and I today are ours, and don't necessarily reflect the opinions of any organization. I want to encourage folks to pipe in and add their perspectives. And obviously that same disclaimer goes for anybody that wants to speak up today as well. Our opinions are our own. I would encourage folks to ask questions throughout the course. I know I was looking at the list of folks that had registered for today, and it looks like some of you have maybe some privacy background. I don't know who else online yet and able to join us. But this space has been changing a lot and quickly over the past months, year. And so as though some of you may be dealing with some of these issues internally, would be happy to have you add to the conversation. So please do feel free to interrupt us. You're not going to offend us. And I think it'll make it more enjoyable for all of us to have a little bit more of a discussion. So with that, our agenda for today, we'll go through a little bit of the latest that's happening at the state level, the federal level, internationally. We'll talk generally about some of the trends in litigation that we're seeing and some of Megan and I's thoughts on maybe what's next for the data protection and data privacy space. So a lot to cover, but we'll get through it. Just as an aside, when we start talking data privacy and data protection, just to make sure we're level set on some of our terminology here. When we're talking about data privacy, we're talking about an individual's ability to control their data, right? When I or Megan or Evan or any of us are out shopping and data is being collected about us, when we're talking about our ability to control what happens with that data, that's what we're talking about from a data privacy perspective. Data security, then we start looking at what a company's obligations are with respect to the data that they have in their control. If you have a data security issue, you are necessarily going to have a data privacy issue because that data is going to be used for a purpose, potentially used for a purpose that the individual did not intend. So really two sides of the same coin. You'll hear a lot of people obviously talking about data security and cybersecurity and all of those kinds of things, all of which are very important, but those are also leading into data privacy issues and some of these data protection laws that we have out there. And so something to bear in mind as we look at these issues. So one of the things, if you guys don't live and breathe the data protection and data privacy world, one of the things to bear in mind is that the United States is different than many of the countries that are out there. From a European perspective, and it's fascinating to have this conversation with somebody who lives and works in the European Union, their vision of data privacy and data protection is truly a fundamental human right? And that is the approach that their laws have traditionally taken. 1995, you had an EU data protection directive that was superseded in 2018 by GDPR. Any privacy practitioner's favorite four letters. And they've kind of continued the trend on some of the cutting edge stuff on data protection with the EU AI Act back in 2024. And they've taken it further than that as well, which we can touch on a little bit later, time permitting. The United States has historically taken a very different approach to data privacy and data protection. We have more what you would consider sectoral laws. back in the 1970s, late 60s, people were concerned about credit reporting. And so we addressed credit reporting. And then people were like, what about student data? Okay, let's address student data. The late 80s, early 90s, everybody was getting robocalls and junk faxes. So let's address that issue. And so has continued in that course through the history of the United States and our legislatures to address the things that on a sector by sector basis as those issues and concerns have come up. We've never as a society sort of taken a broad brush stroke with respect to data privacy and data security the way that they have in Europe for any number of historical reasons, which again, it's a fascinating conversation to have with a European. But the result of that then is from a United States perspective, because we don't have kind of a comprehensive approach to data privacy and data protection, individual states started popping in and trying to address that gap. So we've now ended up in a position in the United States where we've got a number of states that have stepped in and given some thought to this issue. So I think with that, Megan, I'll kick it over to you to talk a little bit about what the states have done in the past decade.
That's great. Thanks, Heather. So let's turn our attention now to what's been happening at the state level, which is really where all the action is in data privacy law in the US. As we'll talk about, and as you likely recall, we don't have a comprehensive federal data privacy law. And spoiler alert, doesn't look like we're going to get one anytime soon. So the states have stepped in to fill that gap, and they've done so aggressively. What has started with California back in 2018 with the CCPA has really turned into a wave of legislation across the country. For those of you managing privacy programs in California, you're already living with the reality under CCPA and CPRA. But as your businesses operate across state lines, the compliance picture gets more complicated every year. So let's start by looking at the current landscape. This slide just gives you a visual. It's from the International Association of Privacy Professionals. It gives you a visual of how quickly state comprehensive privacy laws are being enacted throughout the country. In 2023, there were only about 5 states with consumer data privacy laws in effect, which were essentially California, Virginia, Connecticut, Colorado, and Utah. And then by October of last year, that number quadrupled. So here's where we stand today. You can see from this map just how many states have now enacted comprehensive privacy legislation. As of this month, we have 23 states with comprehensive privacy laws, and the most recent is Vermont, which was signed by their governor this month on June 16th. Michigan and North Carolina have bills that are moving and have been introduced in the past few months, and there are hundreds of privacy-related pieces of legislation introduced in U.S. states throughout the years. So the patchwork continues to grow year after year, and the laws are passing and accelerating quickly. For in-house counsel, this means your compliance obligations are expanding significantly, though as California counsel, you already have one of the most robust compliance programs in the country because CCPA and CPRA in California demand it. But unfortunately, the California compliance program doesn't automatically satisfy other states' requirements. And we can't continue to assume that a California exemption from a privacy law will also exempt you from other state privacy laws. But the good news is California companies have a head start. And building a compliance framework has to be flexible enough to meet both the strict California requirements and the nuances as these other state laws come online. Sorry, there we go. A majority of state comprehensive privacy laws have specific threshold triggers. And whether these laws apply to your organization really depends on a handful of familiar factors. doing business in the state, annual gross revenue, number of data subjects in that state, and whether the business qualifies as a small business administration, which is one that is often forgotten, but a very key threshold question, because that will get you into exemptions in a number of states. These thresholds will vary by state, which adds to the complexity. But some states set the bar relatively low. So you might trigger applicability with just 25,000 or 35,000 customers or consumers in that state, and others have much higher thresholds, including revenue thresholds. California's thresholds are among the broadest in the US, so many of your businesses are already caught. But if you do businesses in other states, as most California businesses do, you need to determine what else you are triggering in those other states. And it's important to refresh this applicability analysis periodically as your business grows and the thresholds continue to evolve. And something we'll sort of lean on as we go through our slides here today is whether your business wants a sort of lowest common denominator approach to privacy compliance. There are very good business reasons oftentimes to expand your privacy program that you have in California to consumers in other states whose residents would not have those rights, but for the fact that you're expanding California rights. It's difficult to manage a program that is different on a state-by-state basis, but there are oftentimes business reasons like perception, right? Why do the California employees have protections that I don't have in Florida? Stuff like that. Employees and consumers, something to think about whether there's business reasons for that expanded approach. Okay, so what questions should you be asking internally to determine whether state laws are applicable? I'm going to walk through these because they're the kind of questions that the legal team should really be relying on finance, marketing, HR, other departments to help coordinate. These are not expectations specifically of the legal department. So first, you have to know your annual gross revenues as of December 31st of the prior year. And you want to know what they currently are because some thresholds look at a trailing 12-month time frame. So it doesn't align with fiscal year or annual gross revenues on a calendar basis. So you would then need to know how many consumers from each state are in your databases. That includes not just active customers and consumers, but prospects, leads, anyone else whose data you're holding. You want to ask how much revenue you've derived from online behavioral advertising and cross-contextual advertising, because that triggers additional obligations in several states. Have you received discounts or products or services when you're selling your data? Any revenue earned from selling the data? These are questions that your marketing and data teams need to be able to answer for your legal team. How many employees do you have? Do you have employees and vendors and contractors in California specifically? For this audience, probably the answer is yes. But the question matters for your counterparts in other states who are potentially assessing whether California law reaches them. And then again, as we flagged, do you qualify as a small business administration? A small business under the Small Business Administration. So yeah, we work with our clients to build internal questionnaires and intake forms around these questions. And then you want to revisit this analysis at least annually because these answers will help you determine your obligations under state law. So now the good news, if we want to call it good news. These state laws do share common features. Most of them apply to only consumers, and we can thank California for that distinction. Other states generally provide similar consumer data rights, so access, deletion, correction, opt-out of certain types of data processing, and they impose similar affirmative obligations for controllers of data and processors around security, risk assessments, contract requirements, what have you. There's also a consistent focus across the state laws on sensitive data. with heightened protections or opt-in consent for data processing of sensitive data and for automated decision making, which is becoming increasingly important as folks are deploying AI tools. So while this patch mark is complicated, there is a common core that you can build your compliance program around. And frankly, because California's law is among the most comprehensive, many businesses that are already subject to CCPA are already doing what the other states require. The challenge really is just in the details and the variations between state programs. Okay, of course, the devil's in the details, and there are important nuances to watch for. And that's what makes a one-size-fits-all compliance approach difficult. So some states require affirmative opt-in for sensitive data processing, as I just mentioned, but other states allow you to process sensitive data, but just subject to an opt-out right. So if your business operates in states that require opt-in consent for sensitive data, you cannot simply extend an opt-out approach nationwide, because this is a significant operational difference and it affects how you design consent flows and onboard new customers. And this is one very particular and probably the most difficult example of why we can no longer build these one-size-fits-all, comply with the most restrictive law, i.e., I'll comply with California and just apply that everywhere. So you do need to customize specific state requirements when they directly conflict with each other in terms of operational processes. Some states provide consumers with appeals rights if you deny their data request. So you have to have an internal process for appeals. California, notably, includes employees within its consumer protections, and that's an area where most other states have explicitly carved out employee data. So you've got obligations around employee data in California that counterparts in, for example, Texas or Virginia simply just don't face. You'll also see that there are important variations between state laws in terms of how selling and sharing data are defined. What constitutes a sale of data in one state is not necessarily a sale in the other states. And sale is not a colloquial term. We don't just think of it as here's the data, I'll take some money. It's a very broad definition that gets you under the definition of selling and sharing data. Also, sharing data for cross-contextual behavior advertising is a uniquely California concept under CPRA that other states haven't adopted. So your experience in California managing those do not share my data obligations may not directly translate how other states are handling similar advertising activities. And taking off our lawyer hats and just stepping into our consumer hats, this is a complicated issue for consumers certainly to face. There's also a whole additional layer of sector-specific state legislation that sits on top of or alongside these comprehensive frameworks. On the employee side, we have laws that address workplace-specific privacy issues, like monitoring, surveillance, automated employment decisions, and they often require notice or consent for certain types of monitoring. We have a few listed here, but it's also important to pay attention to laws in other states like Texas, Maryland, Montana, and Washington. For California employers, these requirements layer on top of the employee protections you're already navigating under CCPA, so the California CCPA, CPRA, and the employee monitoring laws. Another high-risk area, biometrics. We're seeing compliance issues increase along with the increased use of biometric data collection for business operations. So fingerprint, login clocks, voice prints for ambient transcription or access to Teams accounts. We've got the Illinois Biometric Information Privacy Act. We've got BIPA, and that's pretty much the gold standard for biometric privacy. And that continues to generate significant litigation and has really been a wake-up call for companies that are using these fingerprint scanners, facial recognition technology, what have you. BIPA is still important because it does have some extraterritorial application to be watching, particularly if you have an office or leadership team based out of Illinois itself, even if the employees are not themselves in Illinois. Another highly regulated area is healthcare. So we have health-specific data laws like we listed here in Washington, Nevada, and they apply to health data that is not otherwise regulated under HIPAA. So think health apps, wearables, wellness programs, employee assistance programs. These laws have very restrictive data use options, including separate consent requirements for collecting and using data. So if your California-based company is offering wellness benefits or health-adjacent products for consumers in Washington or Nevada, these laws are going to reach you. Your compliance program can't just focus on the comprehensive law. We need to look at additional state-specific requirements.
And just one thing to interject. Sorry,
Yep,
just one thing to interject there on the biometric stuff. Because I've had this conversation with a lot of folks and they're like, yeah, biometrics. We're not collecting fingerprints. We're not doing, 007 iris scans. But there is a question when you start to look at Teams and Zoom and all of these tools that we're using every day that are making recordings, and they're making those voice recordings, and they're monitoring, they're recording the video. Is that, are you inadvertently triggering voice prints, facial rec, those kinds of things? And so it's something to bear in mind and look carefully at all of the tools that could be possibly triggering that, because we're finding a lot of that stuff from a voice print and facial recognition perspective can inadvertently trigger biometrics, which we wouldn't normally think about.
Yeah, great point, Heather. And all of those IT contracts significantly shift the burden for compliance onto the customer. So absolutely important to understand when your use of those products are triggering these laws. And as Heather mentioned earlier, we're not here to talk, specifically about security, but I just wanted to take a moment here as a quick aside to note that Massachusetts maintains one of the few, if only, data security statutes, and it's more prescriptive than all of the other states and even federal standards for cybersecurity. So regardless of whether you have Massachusetts presence, taking a look at their law can be really helpful for your InfoSec team, because it is a good way to demonstrate that you have industry standard, reasonable security standards. Okay, a couple of quick notable updates in the state privacy law space that we wanted to flag. First, we're seeing states address what we call the oops factor, right? So situations where companies have made a good faith compliance effort, but they've stumbled in execution. Some states are providing cure periods or structured enforcement approaches that will give companies an opportunity to remediate before penalties are applied. That's a positive development. It's not universal, and notably, California has eliminated its 30-day cure period. So California businesses are already operating in this more demanding enforcement environment. The second thing I wanted to mention, global privacy control mechanism, it continues to gain traction and is becoming a real compliance imperative. Several states now explicitly require companies to honor universal opt-out preferences. Unsurprisingly, California led the way here through CPRA regulations, but other states like Colorado and Connecticut have followed suit. So if you have not already integrated GPC recognition into your consent management platform, that should be a priority. And remember, it's not just about detecting the signal. You're going to want to actually suppress the processing activities that the consumer is opting out of when you receive that signal. So the trend at the state level is clear. More states are enacting privacy legislation, and the ones that already have laws on the books are considering amendments and expansion.
Yeah, and it was kind of interesting. I mean, we've been, as I mentioned, we've been talking and giving this presentation for a number of years, and I kind of thought it would slow down We're at about, up until the end of last year, I think it was. I mean, we had like a pretty core group of states that had acted in this space. But we've got more, right? We've got Oklahoma, Alabama, Vermont, and Louisiana all coming online in the next year. So it certainly does seem to indicate that we're going to continue to see this drip state data protection stuff. And as we'll look here in a minute, AI is going to continue to push that forward.
Yep, it wouldn't be a privacy presentation if we didn't mention AI at least for a little bit. We've done really a formidable effort. We've limited AI to just 2 slides here. So as we sit here in 2026, the legislative activity at the state level has not slowed down when it comes to AI. And we're expanding into a number of different areas. Again, states are stepping into the vacuum left by the federal government. And state legislation is really falling into 4 or 5 categories. So first, high risk AI regulation like employment, housing, lending, insurance, healthcare. Second, transparency and disclosure requirements for AI generated content and AI interactions. Think the chatbots. Third, anti-discrimination and algorithmic fairness requirements. So making sure our AI is not creating bias issues. Fourth, limitations on automated decision making. And then fifth, as we see in privacy, also some sector specific regulation. So here's another set of maps from the International Association of Privacy Professionals, just showing 1 year of change in terms of comprehensive AI legislation in the governance space. We're seeing more proposed and signed AI legislation from these states. All 50 states considered AI legislation in 2025, and 38 states have adopted some type of AI legislation. For California, this is especially relevant because California is the most active legislature in this space, with bills targeting AI in HR and hiring, AI-generated content disclosures, use of AI in consequential decision makings that affect consumers. We already have the automated decision-making provisions in the California Privacy Rights Act regulations, and they're just beginning. So you should be thinking about how your company's use of AI tools, whether for customer-facing or internal, like HR processing, intersects with these emerging obligations. If you're developing your own AI internally, there's a whole additional set of laws focused on privacy implications for developers. And a related issue to AI, especially if you're developing AI, is the regulation of data brokers. This is, once again, an area where California is leading the nation. California's Delete Act fundamentally changed how data brokers were monitored and supervised, right? It creates a streamlined mechanism for consumers to request deletion of their personal information from all registered data brokers through a single request. So all data brokers that operate in California have to register and comply. And again, this is one where you should take a look at the definition of a data broker, because it's not just those businesses that we think of that are buying and selling data in exchange for cash. But this will still matter to you even if your company is not a data broker. You want to understand whether your vendors or partners qualify as data brokers, if you're purchasing customer data from third parties, or if you're sharing data with certain entities that will aggregate and resell data. There's a chain of compliance obligation that will flow and is worth tracking. And here the enforcement teeth are real. Failure to register carries significant penalties. And not just in California too, we've got other states, Texas, Vermont, and Oregon, I believe that's the last one, have data broker laws on the books. So taken together with the data broker laws and the AI legislation that we just discussed. Message is clear. State level regulatory environment is expanding in scope and complexity. Happy to talk to anyone offline or come back again to talk about AI governance requirements, but just as an overarching recommendation, we should be mapping our AI use cases, auditing our data broker relationships, and building cross-functional governance teams together that will bring together the privacy team, technology team, procurement, legal, marketing, HR to address all of these converging requirements.
Yeah, and I was going to pipe in, and we've actually just had a question drop in the chat on this topic as well. So it's very very timely. I didn't plan this, but to the extent that you're sitting at your desk saying, you know, why are we talking about AI in the context of a data protection presentation? And they really just wanted to throw in AI because that's the new fun term. When we talk about developing AI and we talk about how AI comes to be, AI craves data, right? For AI tools to work appropriately, the massive amounts of data that they have to have and that you have to have for training and development purposes is astronomical, obviously, more or less depending on the type of tool that you're developing. If you start developing AI using data for which you did not have the right to do so, then you are jeopardizing your entire AI project. Going back several years, even at this point, well before some of these states started pushing out AI regulation, the Federal Trade Commission was known to, and I'm forgetting the name of the enforcement case that they brought, but it was an app developer that was building a tool that would EverAlbum. That's what it was called, FTC and EverAlbum. EverAlbum tried to develop a software tool where it would recognize facial images and create your EverAlbum, create your photographic album that could live forever. But what they didn't disclose and what they didn't do properly is when they were building their algorithm and building their app and training it, they were scraping photographic data of individuals from all over the internet and using that data without appropriate consumer consent. And the FTC made them destroy their algorithm. Algorithmic disgorgement is a real thing. And if the regulators think that you have built your AI using data that you should not have had, that is a remedy that they will commonly look to, is say, okay, you built this tool using data that you should not have had, data for which you did not have consumer consent, or the consumers did not have sufficient disclosures. You have to destroy it all. And nobody wants to be the one walking into the CEO's office saying that the project that you just spent however many millions of dollars developing it is going nowhere because you had to delete and destroy the code. So that's why we start talking about privacy implications when we're in the AI developer setting, because you have to have data for that AI development. And if that AI or if that data is tainted in any capacity, that's why Megan is mentioning, right, looking across your supply chain for data vendors. Even if you're getting data from a vendor and that vendor is a data broker and they haven't complied with something, like looking up that chain to make sure that you have the right tools that you're developing your AI with is fundamental to having a successful AI development project. So Megan, I don't know if you have anything else to add to that.
The only other thing I would add is that if you're intending to commercialize AI that you're developing, there are sort of standalone AI laws that apply to, for example, disclosures that you as the developer have to make to your customer. So there are additional steps that you need to build into your development in order to be able to meet those expectations of your customers.
Yeah.
All right, let's jump ahead.
Yeah, so let's jump ahead, but hopefully that answers the question of what some of those privacy implications are for AI development. And we'll switch gears a little bit and look at the federal level. There's frankly not much going on at the federal level from a data protection perspective. There has recently been introduced, the Secure Data Act is the most recent development that was introduced in Congress. I'm very skeptical about whether it goes anywhere. for any number of reasons. The one that we put up here on the slides, AGs are significantly pushing back. The California AG led the initiative to send in a letter. I think 17 state AGs signed on to his letter to object to this, mainly because now we have so many states that have their own laws on the books, and what the Secure Data Act would push out is less protective of consumers than what the states themselves have. So the states are opposed to it. Data protection legislation has not gone anywhere really at the federal level for the past couple of decades. So I don't particularly see that changing. We threw up here on the screen, and for anybody that has access to IAPP, they do, and I think Bloomberg does as well. They've got some nice charts and some nice statistics on the stuff that does get introduced. We pulled down like the latest from IAPP. Like there are laws introduced occasionally on consumer privacy, workplace privacy, financial privacy. We put some of the ones that have been successful up here a little bit. The Take It Down Act was from back in September of 2025. So from a data protection perspective, we get a little bit at the federal level, but we are not, I don't anticipate any kind of far-reaching, comprehensive consumer data protection laws anytime soon. And I will be very surprised if the Secure Data Act goes forward in any capacity. For the most part, I think if we're going to see anything at the federal level, it's going to focus on children's safety, and there are some initiatives at the FTC to kind of look at COPA. They're calling it COPA 2.0, and some of the children's data stuff that's out there. But I don't think we're going to see much at the federal level. Kind of turning to that AI question, I think we're going to even see less from the federal level than we are seeing at the states. White House has very, very firmly implanted themselves into the deregulation innovation camp. The concept that any kind of regulation on AI, any kind of oversight on AI is going to stifle innovation. And we need to be the leader of the pack when it comes to AI development. And therefore we're not going to support any kind of regulation. There have been a number of executive orders out of the current administration along these lines, and I foresee that would continue to be the case. There are some agency enforcement trends, primarily out of the FTC, primarily looking at kind of, as Megan mentioned, some of the state laws that have like the transparency obligations. So bear in mind that even outside of the AI context, there are still consumer protection laws out there, and much of what the FTC enforces from unfair and deceptive trade practices. And so from that concept of consumer transparency, we're still seeing some FTC action. The FCC, the Federal Communications Commission, is continuing to look at AI-generated robocalls. So there's some activity at the federal level, like as you look at each stream of federal agency, in the context of AI, the SEC looking at false and misleading AI statements on filings and things of that nature, but no big broad push from regulation at the federal level. Generally speaking. And so do we hold out any hope that is going to change? And the answer, I think, is no. We're going to continue to see this patchwork of state laws and regulations, both on the data protection side as well as the AI side. It will be interesting with respect to the enforcement of those state AI laws and how that comes to pass. Most of those state AI laws are new enough that it's early stages from an enforcement perspective. But the federal government has, under the current administration, has really made a push on disincentivizing states to enforce the AI laws that they have, again, with an eye towards encouraging more innovation, as opposed to anything else. So I'll pause there. Does anybody have any questions? We've gone through the state and the federal updates at this point. So if anybody has anything they'd like to pipe in, or if they're having just super fun times dealing with all of these state statutes and their management programs to have vendor management and data protection obligations in place, happy to chat a little more practically about some of those. Otherwise, we'll turn our direction internationally and see where that takes us. So seeing nothing in the chat. From an international perspective, India is not probably the most recent one, but it was the most recent significant international country that passed their broad data protection coverage. It was the final rulemaking, I think, went through like November last year, and they now have obligations coming into force in May of 2027. So there's about a year to come into compliance with some of the requirements under the Indian law. And India was, as I mentioned, one of the most recent significant, given the population of India, and the number of people that the passage of that law now brings in to broad consumer data protection. And if we flip to the next slide, with that passage, what that means is that currently there are 144 countries, 145, we'll talk about Pakistan and Bangladesh, as of January of last year, that now have data privacy and protection laws in place. That means about 82% of the world's population is currently under data protection, broad consumer data protection legislation. This is one of my favorite little tidbits, and I did verify. I think it is still factually correct. I was Googling world populations to see if my numbers are still right. But if you look at the most populous countries in the world without comprehensive data protection laws, the United States is among quite an elite set here. And honestly, actually, Pakistan and Bangladesh both either have draft legislation, and Bangladesh actually just enacted their own personal data protection order in November of last year, and that's going to start moving forward. So my list is getting shorter of most populous countries in the world that do not have broad consumer data protection. We are now down to United States, Iran, and Iraq. And then you start dropping off into smaller countries. Afghanistan, I think, has like 40 million people, and so on down the line. But in terms of populous countries without broad-based coverage, the United States continues to top that list worldwide, which is a fascinating statistic when you think about it. We'll touch a little bit on Europe. GDPR continues to be, and as it was, one of the first sort of broad-based legislative efforts with respect to data protection. We'll contemplate a little bit about what's going on there. For any of you guys that have been doing business with companies that are based in Europe, or yourselves within the purview of GDPR, you need a lawful basis to be able to process personal data, and a basis upon which to transfer that personal data outside of the EU. In order to do that, one of those bases has to fit within one of these 4 bullets, right? Either the country you're transferring it to has to be the subject of an adequacy decision from the European Commission. The company has to be subject to internal binding corporate rules to facilitate intercompany transfers. Standard contractual clauses are still a thing, and is the primary way that we get data out of the EU. Or you can seek a derogation from a data protection authority. But if it's not one of those 4 things, getting personal data out of the EU, then you're just really not really not supposed to do it. And of course, as we talked, the structure of US data protection laws does not fit into any of those buckets. So when a little bit of a walk down history lane here, when GDPR first came, actually even before GDPR, under the data protection regulation, Max Schrems had struck down the safe harbor to have data pulled out of the EU. Safe harbor was replaced by Privacy Shield. Again, Max Schrems had Privacy Shield struck down. For anybody who doesn't know who Max Schrems is, fascinating character, Stanford trained lawyer, who is European, and has tended to be the impetus for challenging any of the structures that the Department of Commerce and the EU Commission come up with to try to get data out of Europe and into US businesses. Coincidentally, the Privacy Shield and Safe Harbor were really pretty much the same thing, which brings us to what we currently have, which is the Data Privacy Framework. Again, pretty much the same thing in terms of the requirements of the program. So Data Privacy Framework is currently one way to get data out of the European Union. You have to self-certify. It is a voluntary program. It is, if you participate in that program, once you are declared certified, then that becomes enforceable as law against the company participating. And then that participation is deemed an adequacy decision to serve as the basis for receiving that transfer of EU data. It's a relatively inexpensive process to go through, as you can see from the numbers. The numbers vary based on the size of the company. And you do have to pay attention, because Switzerland is not part of the EU. Then there is a separate Swiss framework as well. So you have to pay attention to which one you're looking at. If you do elect to participate in the framework, you're essentially certifying that your business complies with 7 primary principles and 16 supplementary principles, all of which are relatively straightforward when you start thinking and looking at data protection concepts. Notice, giving consumers notice, choice with respect to data, accountability for the transfer of it, security, data integrity, limiting the purpose for how you use that data, the access to that data, and then recourse, enforcement, and liability. So fairly straightforward principles. The 16 principles get into a few more nuances and components of that that we won't go into for time purposes here. When the EU Commission deemed participation in the data privacy framework adequate back in 2023, in large part, it relied on a Biden executive order in doing so. So after Biden left office, and one of the first things that the Trump administration did was rescind a bunch of the Biden executive orders. There was a French member of parliament that challenged the data privacy framework on that basis. The challenge was actually dismissed in September of 2025. But if you read the dismissal, it was very narrowly worded. And so I have been waiting for somebody else to challenge the data privacy framework from an EU perspective. We'll see what happens. The challenge that was dismissed from the French member of parliament, he did appeal at the end of October. The case is now currently sitting at the Court of Justice for the European Union. So we'll see what happens there. It was the CJEU that also struck down the frameworks that were in place under the Schrems litigation. So we'll see what happens here. But if in fact the adequacy decision from the European Commission was based on a Biden executive order, and that executive order no longer exists, it'll be interesting to see how they can justify continuing that holding up that adequacy decision on a go forward basis. But that remains to be seen. Europe, of course, continues to hold our attention with their EU AI Act, which was also first of its kind AI legislation. Europe truly considered anticipated that the EU AI Act was going to be the new GDPR, that they were going to be the ones setting the standard for AI regulation going forward. That has not ended up being the case. As you can see from the dates, the dates on here, all rules were supposed to have been applicable in like a month, right? August of 2026. And if you skip to the next slide, there was significant angst in Europe as these dates started to approach. There were some significant conversations about the discussions and around discussions and concerns about the cost of compliance. And it was going to be extraordinarily expensive, allegedly, for companies to comply with. There were those same concerns that the Trump administration has had around innovation, that if you're going to have AI regulation, you are necessarily going to stifle innovation. But ultimately, just, and you'll see the quote up here, the compliance ecosystem just wasn't ready. There was supposed to be some additional guidance and rules that were supposed to have been published that were nowhere near ready. And so it became known that those original deadlines of August of 2026 were just widely acknowledged to be unachievable. And so earlier this year, the digital omnibus, I always want to call it legislation. I don't know if they technically call it legislation, but regardless, there were initiatives starting in March of this year that were ultimately, the political agreement was approved in May of 2026 to have a digital omnibus that implicated some of the deadlines for the EU AI Act. That was recently approved by the EU Parliament. And the effect of that is going to delay some of that enforcement of the EU AI Act until December of 2027, and for certain regulated products, and until even later than that, August of 2028. So it'll be an ongoing conversation with respect to some of these things. The digital omnibus implicated some of the rules around GDPR as well. So Europe is looking at this entire ecosystem of data protection and AI from a holistic perspective, and trying to get to the right place. So I think that's all I have internationally. I know we have about 5 minutes left, so we can touch on a little bit of some of the trends in litigation that we're seeing.
Yep. So what's happening in the courts seems to be just as important as what's happening in the legislatures. Obviously, we see a new trend in data breach litigation, which we're not going to talk about here today, but the expectation now is if a data breach occurs, there is likely going to be a class action filed shortly thereafter. But we wanted to focus here on pixel litigation. So the theory here is expanding wiretapping claims based on cookie and pixel tracking technologies. So the theory is plaintiffs argue that when a website collects data via its cookies or other tracking tech without sufficient notice or consent to the website user, that is essentially the equivalent of wiretapping. So it's intercepting communications without authorization. Courts in several jurisdictions have been receptive to these arguments. We've got a cottage industry now, and it's very similar to what we saw with the ADA website accessibility claims years ago. So the amounts at issue can be small enough, often just in the thousands, that it makes economic sense for companies to settle rather than litigate, which is why I think we're seeing this trend continue for a while. But the low cost in plaintiffs' bar reviewing websites for tracking technologies and the potential volume of affected consumers, website users, is high enough to keep the plaintiffs' bar and some very active pro se litigants motivated to continue to file these cases. Oftentimes, these cases turn on whether consent is required, particularly in states that have all-party consent requirements, like California. So what's the key takeaway here? We need to have proper notice at the point of collection of data. But what does that actually mean? No US comprehensive privacy law currently requires European-style cookie banners, but operationally, how can notice be provided to consumers or opt-in consent collected when required before cookies are deployed without using something like a cookie banner? So this is an ongoing discussion, particularly in California, based on risk under SIPA. In addition to the banner, we got to make sure that our consent management platforms are properly configured to actually enforce that opt-out. And we want to make sure that privacy policies accurately describe what tracking tech is being used and what data is being collected. And for all of us here and California companies specifically, remember that SIPA, the California Invasion of Privacy Act, which predates the internet, is still one of the primary statutes being used in these claims. So it's very much a home jurisdiction risk. Good news is courts and legislatures are responding to this wave. We're seeing the Supreme Court of Massachusetts, which weighed in the fall of 24. And then particularly for legislators, the SIPA was put on a 2-year road to amendment. So the legislature in California has recognized that these older wiretapping statutes were written for very different eras, non-technological internet era. And the legislature decided to address this. So in the meantime, this litigation is very much robust, and we need to be proactive about compliance posture. As California businesses, you're definitely in those crosshairs. The last thing to flag for SIPA litigation, we're watching litigation involving Google that touches on a lot of these same themes with multiple legal theories that we've included here on the slide. What's notable about this case here is the breadth of theories being advanced, with plaintiffs' counsel throwing multiple legal frameworks to see what sticks. And the outcomes here are going to set important precedent for how we think about data collection practices generally. So these theories will eventually leak out of California and almost certainly influence how claims develop in other states. So this is one to keep a close eye on, the Google privacy claims. So with our last minute here, Heather, do you want to just quickly run through what's coming next?
Yeah, so I mean, I think in some the states are going to continue to push out their own data protection legislation on a state-by-state basis. We don't anticipate anything being successful at the federal level, and in fact, anticipate some significant state pushback if folks try to go down that path. Existing laws are going to continue to be amended. And so as much as I would like to say that we've got kind of a steady state of, the 23 states that we'll have as of the first of the year, there's going to continue to be more churn even within those. From an AI perspective, most of, or at least more significant action, I think, is going to happen on components that implicate automated decision making. That seems to be kind of one of the higher priorities within AI that regulators can coalesce around and have some have some thoughts on. And because those automated decision making concepts are in a number of the state laws, that's going to continue to be one of the primary pushes. And as I mentioned, to the extent there's any agreement among both regulatory authorities and legislatures about priorities for data protection, it's with respect to children, particularly children online. And so we'll continue to see some of that taking place as well. But the other thing to mention on the enforcement side, many states are actually starting to work together and pool resources. So as you can see, some of the more active states, Colorado, California, Connecticut being 3 of them, and Texas is continuing to expand its staff to pursue regulatory actions. I think we're gonna continue to see more of these states working together to try to go after companies that they think are not in the consumer's best interest. So last but not least, one of the interesting things, we're starting to see states that are enforcing on data protection stuff, even without any sort of data protection legislation. Kansas within the last year had an action under their deceptive trade practices statute that they pursued. So just because your business is operating in a state that doesn't have one of these laws on the books doesn't mean that you're not going to have any risk. It's just going to take a slightly different form.
So with that, thank you all for joining us today. Feel free to drop any remaining questions in the chat, and Heather and I are happy to follow up with you offline, but thank you for joining us.
Thanks, everyone.
Thanks, Heather. Thanks, Megan.